Well, thanks for coming, everyone. We're really excited for the interest in this topic, and I want to welcome people who are both here live and on the webinar. I'm Jamie Nafziger, the chair of our Cybersecurity, Privacy, and Social Media group here at Dorsey, and I'm really happy to see everyone here today. I wanted to take a step back before we start with the substantive panels and talk about why we have 400 people plus signed up to come talk about privacy for half a day in September. So how did we get here? I like to talk about the grand bargain of the internet, which is basically that we get lots of cool stuff for free or for very low cost in exchange for our personal data. And really, I think that what's happened in the last few years is our world is having some big emotions about the internet. On the one hand, we love the internet. It has revolutionized so many portions of our lives, from dating to job search to shopping to just getting information to getting from place to place. It's made our lives a lot easier and a lot more fun, frankly. So we have this love of the internet and all these cool things that our companies have come up with for us to do. We also have, I don't know if you really call it an emotion, but this feeling of flow with some internet things where I can drive somewhere, my phone tells me where to go, and I can just enjoy the music. So it's got these wonderful aspects to it. The flip side is that because it's so open and because it has all these cool things, we have to pay somehow, and we haven't really paid with cash for the most part. We've paid with our data. Well, we have this sweeping California law that's coming into effect in 104 days, and it's kind of changing this grand bargain of the internet, and we've been seeing that in Europe too. So because there are a few other emotions that have come into play with the internet besides love and this feeling of flow, we've got some anger, and we've also got some desire for vengeance, and that relates to some huge data breaches that have happened. You've heard in the news day after day about Yahoo, Marriott, Equifax, the Aadhaar breach in India, all these huge breaches, and it's a constant hum in the background that makes people angry and makes them feel like they want some vengeance for their personal data being stolen or lost. We also have this kind of creepiness factor, I call, which is like things are doing things that you didn't expect them to do. Maybe you signed a privacy policy or you accepted a privacy policy that said that was going to happen, but you didn't read it. And now you're surprised that your TV is recording your conversations in your house, or that your facial recognition is being run on your family photos, and people get afraid of that, frankly. And then you think about the Snowden revelations about government tracking, and people feel afraid about that too. Really, for marketers, the best thing would be if we could have this brain-machine interface. So you may have heard that Elon Musk's company is working on something like this, where you could just plug right into my brain and know, if I'm looking at that red car that's up on the screen, am I feeling, oh my gosh, that looks like my ex-boyfriend's car, I hate it? Or am I feeling like, I love that car, I really wish I could buy it, but I don't have enough money? Or am I feeling like, I am buying that car this weekend and I just need to pick my options package? Because we can't read our minds like that yet, the best thing we can do is have cookies and pixels and other tracking things that allow companies to guess at which of my emotions might come into play when I see that photo. And then there's also the emotion or feeling of wanting fairness. And so here in the US, we watched in Europe as GDPR came into effect, and people realized that people have all these rights. And people are like, hey, why do the EU folks get all these rights? We want these rights too. And that's how we come to today, which I think is a tipping point for the internet. And we've seen what's happening in Europe. We're going to have it here. And it'll be interesting to look back in 10 years to see what our internet looks like. Is it still this open place where you can find just about anything? Or is it a paid place where there's no advertising, but you're paying for each little thing you want to do? Obviously, some people were hoping we would have a federal privacy law that would swoop in and save us all from CCPA. And even last week, more than 50 CEOs sent a letter to Congress asking for it again. But we're not going to have that by January 1st. So we're charging ahead with CCPA. And as everything's evolving, there have been amendments passed last Friday, you've probably seen. We have an article that we've handed out to you that talks about the amendments that were passed last Friday. So I refer you to that. There are 5 that were passed to the CCPA, and there was also one that's not mentioned in that article but would be relevant for you that has to do with amending the data breach statute, which is AB 1130 in California, to add a couple more categories of IDs and also biometrics, which has been a big theme across the US for amending data breach laws. We've got some amazing guest speakers here today, and we're so excited to hear their perspectives on everything. I ask that you sign the green sheets for each session that you're in on your table so you can get your CLE credit, and we know you were here. I want to welcome you all to a reception that will start after our last panel right outside here, so we can continue the conversation with you and answer questions that you did. We're going to probably hold questions during the sessions, and we can talk about them after. If you're on the webinar, if you have questions, you can email Dorsey, the letter U, at dorsey.com, and we will respond by email to those questions. With that, I will turn it over to our first panel, and thank you very much.
Thanks, Jamie. We've got a lot of ground to cover and not a lot of time to do it. So we're going to take the liberty of skipping the introductions as much as I would like to regale you with the professional expertise of my colleagues here. We're going to jump right into it. I do have the pleasure of working with them and their company, and so we're fortunate to have them. And we're going to go through a series of slides. Some of them are contextual and are going to be very quick to get through them. Just so, for those of you that maybe aren't steeped in this, you'll see how things fit together. There are some spots where we're going to slow down. We're going to take a deep dive, and that's where we hope to add some value for the people in this room. So we'll start with just the basics. Does the CCPA even apply to your company? Here are the criteria. Most of you probably know, but if there's anybody with any doubt, look at our website. We've got a very simple CCPA screening tool that's available to the public. It'll give you a quick answer. It takes less than 5 minutes. So what is the CCPA all about? Here we are. You have to make the disclosures up front. They have rights. Consumers, you can't discriminate if they exercise their rights. The big one that we're going to probably talk about the most is this security piece. You have to have security that's appropriate for the data that you have. And one of the things we're going to spend some time on is, well, what happens if it doesn't work? If your best efforts at providing security for that data fail? There are other panels will cover these about what kind of notifications are required under CCPA, so I'm not going to talk about that. I'm not going to spend a lot of time on consumer requests. Those are in the statute. But what's interesting, maybe backing up a second, both the notifications and the consumer rights are going to create a little bit of a new environment for companies where they have to have more interaction with consumers on a day-to-day basis. There are some exceptions to the CCPA that Jamie mentioned, and we're not going to talk about a lot because some of them are only transitory. But the first piece I'd like to spend some time on is, all right, let's assume, hopefully, that you're set to go on January 1. You've got your procedures in place, your notifications, your ability to respond to consumer requests. Sean, talk to us a little bit about what happens to the company's risk profile when those things are implemented.
Yeah, so there's a couple of things here. For one, the companies, as part of their ramp up to being compliant with CCPA, are going to have to create processes by which they are able to respond to the requests that are coming in. Early on in my career, I worked for a financial institution, USAA, so a major bank. And one of the most common type of incidents that we had to deal with in InfoSec was a mailing gone wrong. So information mailed out, US postal mail, sent to the wrong address. Either the wrong address was on file or the request that came in, somebody couldn't tell the difference between a 3 and an 8. So the information got sent out, and hence a incident or a violation was created. So you could have an issue where a consumer sends in notification, you attempt to communicate via postal mail, as an example, and create a secondary violation because you mismailed something. Now, modern, I would say most companies are communicating electronically, either by having a portal, by email communication, some other ways. So I'm going to skip up a couple bullets for a second. The 5th bullet here, where it talks about Equifax. One of the things that led to Equifax being breached was they had a consumer portal that consumers could go to interact with the agency. That portal had been set up, I believe it was like back in the 60s or 70s, for a good reason. At the time it was set up, it was probably state-of-the-art technology, but over time, it just remained. No updates to it. The people that originally developed it probably didn't even work for the company. In some cases, may have passed away. And fast forward to now, and a tool that had been put in place for communication with consumers on a specific topic was now used to breach millions of consumers' data because the company just hadn't put the resources into it to modernize it and keep it up to date. So there's several things that you're going to have to do. One, you're going to have to look at what is my risk. If I have these systems that are internet accessible, if I have these communication paths, I use email for invoicing. I use email to send, even though you shouldn't, sensitive information to consumers. What is my risk associated with it, and what type of violations or potentially class action lawsuits could that lead up to? The last bullet, to me, is one of the more difficult things a company's going to have to show. And that's, if a consumer requests it, you have to be able to delete the information. There are some caveats. Let's not look at the caveats. But you have to be able to delete the information you have on them. The companies we work with, a lot of times, don't know all of the locations they have information about a given person. They may know a database. They may know 6 databases, but they don't know the fact that somebody in finance has been emailing that consumer. They don't know about the 50 backup tapes that contain information about that user. They don't know about these laptops that contain information about the user. And I think a lot of what we're talking about today is going to be decided through the litigation process in some cases. So at the end of the day, if a consumer says, delete everything about me, and a company misses one set of data about them, what does it mean from a violation perspective? Are they now going to be possibly a class action lawsuit because there's thousands of consumers with information in these unstructured places? Or the court's going to look and say, do you know what? You had a reasonable approach to how you were going to go about deleting information, and we're going to take that into account. I think that's really gray right now about it.
Yeah, and so a couple of other observations. We don't come to this with a blank slate. We've now lived with GDPR for well over a year, and we see some of the abuses, to be blunt, that are taking place. You've got sort of professional plaintiffs probing to try to trip people up. I know no one in California will do that, but it's possible others. So what we're going to, but I think Sean's point about this, well, how do you defend yourself, especially on the adequacy of the security measures? So with your permission, I hope, we're going to skip the discrimination piece because we can talk about that later. We're going to skip service providers because I think that's going to be discussed later. And we're going to get right to the adequacy of security measures. So here's the standard, and it sounds reasonable, doesn't it? Well, so this is the liability that will happen if there's a breach. If a business has violated the duty to implement and maintain reasonable security procedures and practices appropriate to the nature of the information. A lawyerly, one of the few things that's sort of reasonably well drafted in CCPA. What it means is, who knows? What it means for your company may be very different than what it may mean for some other company, based on the size of the company, what's reasonable, based on the nature of the information that one company has versus another. So what I'd like, Sean, for you to, because I know you've thought a little bit about this. So if you're try to be state of the art, and you're ISO 27001 certified, you've got your SOC 2, you've done everything you can. What does that get you at the end of the day if you have a breach?
So I don't know how many of you have seen the information coming out of Sedona Working Group 11 as it relates to reasonable security. So the Sedona Conference has a working group right now that is working through a judicial test for determining was reasonable security in place. It's in draft. I don't know if the current draft is what's eventually going to be actually released.
We're actually meeting tomorrow in Montreal. I'm on the steering committee for Working Group 11, and it's very, very controversial. Yeah. I don't know what we're going to release yet. Yeah.
So let's talk about reasonable security, because the first time I read through CCPA, I got to reasonable security and my eyes crossed, and my brain shut down for a couple of minutes. I'm from the IT side. I look at things from an IT-centric analytical approach to security, and I get to this requirement for reasonable security, and my opinion, there's no such thing. Security has to be identified on a company-by-company perspective, because every company is different, and the way they are storing, processing, transmitting this sensitive information is going to vary widely for each of these companies. So leading up to this, I've been talking with the leadership in my practice. I was talking with the other panel members yesterday and today as it relates to reasonable security. And I still think the courts are going to have a big part in actually determining what reasonable here means. But beyond that, I think the ability to show that you are conducting risk assessments within your organization are going to weigh heavily into the determination of whether the controls you put in place were reasonable or not. So we have all these frameworks out there. We have the CSC Top 20, which I know one of the panels is going to talk about later today. We have the ISO standard. We have the COBIT standard. We have all these information security frameworks that attempt to, or they're really derived or created to help you assess your company's information security program. And then there's other standards that are more risk-centric. So how do we govern risk? How do we identify risk? How do we manage risk as an organization. And if you can't show as an organization how you are assessing your risk and then implementing controls that are reasonable for you as a company, that aren't going to bankrupt you as an organization, but at the same time protect the sensitivity of the information you have, I think you're going to have a hard time at the end of the day arguing that you had reasonable security in place. We talk about a SOC 2. And again, one of the conversations we were having earlier today, there's a lot of companies that provide assessment services. What level of analysis are you letting those companies do? Are you doing a paper exercise where they come in, they sit down with your CIO, your CISO, your CTO, and they ask a question? Do you have an information security policy? Yes. They mark yes on the assessment form. Do you have this? Do you have this? And at the end of the day, all you're getting is a recitation of somebody in the organization's answers with no sort of validation, no sort of independent analysis of what's going on. I think you're going to have a hard time saying that's reasonable security.
So then, go ahead.
No, it's a difficult answer. There is no one definition. But before we move on, let's look at that last bullet really quickly. Can encryption be a safe harbor? So within CCPA, they talk about encryption and being subject to fines if data wasn't encrypted. So it almost sounds like safe harbor, right? If I'm encrypting, then I'm okay. But I think we need to talk about realities of encryption, because I can implement encryption, but if the attacker is able to gain access to an account that can decrypt the data, then suddenly that, my opinion, that encryption, I don't want to use the word safe harbor. The encryption didn't do you any good, right? If admin account was compromised, the admin account was able to see the unencrypted data was stolen. I would say you don't have a leg to stand on if you argue, but I had encryption in place because your encryption was bypassed. So I just want to make, they talk about encryption. I don't want you to leave here thinking if my IT folks put encryption in place, I'm okay, because I don't think that's true.
So maybe we can segue to how are your obligations really going to be defined? Because so much has been written about the confusing nature of how CCPA was drafted. It's contradictory. We've yet to see any regulatory guidance out of the Attorney General, and I'm being a bit of a pessimist on these things. I'm not so sure we're going to get all that much help, but we'll see. So consider this. From the Attorney General perspective, that office has jurisdiction over the kinds of stuff, what do you have to say, what do you have to do? And if you don't do those things, that's where the Attorney General will seek enforcement. The next slide is going to show you about on the private right of action that has to do with data breaches. So there's a two-pronged approach to enforcement, and I think Sean's absolutely right. The real definition of what's the bright line test, if we can ever get one on certain CCP items, will be after someone's tested them judicially. I do want to observe, and actually Sedona's doing a paper on this as well, on per violation, especially on the AG side. And there's a lot of uncertainty. Is it each action by the violator? Is it each individual whose rights were violated? Is it each section of the CCPA that's been violated? And there's some guiding principles that we can make some reasonable suggestions on based on the existing jurisprudence, but it's not at all clear from how the CCPA was drafted what the AG is going to do. So the AG, for much of this, is going to sort of be in their own environment. Where you're most likely, I will suggest, going to face consequences will be if you have the misfortune of a data breach. There, the law is a little bit more clear. It's per consumer, per incident. And it's $100, or if it's intentional, $750. Not huge amounts of money, depending on how many consumers you're talking about. But what if you have some of the breaches we've seen? There are millions involved. I mean, there are very few companies that can absorb that kind of consequence. We've spent a lot of time looking at the insurance products that are out there. There is not enough insurance cover being written today that will handle these kinds of numbers. Just don't exist. So it's a sobering thought. Huh? I wouldn't say it's a bright spot, but a couple of less terrible things is that, as you may recall, the way CCPA was first drafted, personal information was any information relating to an individual. What does that mean? So the legislature said that's a little vague. So they, in the last amendments, they added reasonably relating to an individual. So I'm glad we got that clarified. As you will see, it is a more defined subset of information that would trigger exposure under a data breach. I've given you some examples here, as Jamie mentioned earlier on in the last round of amendments. There's actually some have been added. Even this one doesn't have it all, but biometrics is going to be a big deal, I think, and so it would be my opinion, just to sort of what's the perspective here? It would be a rare incident where personal information was involved that this was not triggered. So the question then is, where do you go from there? We've listed for you what the criteria are, nature and seriousness of the misconduct, number of violations, et cetera. I think that these are important. They're things that lawyers like to argue about. But at the end of the day, how many people are involved, and that's what's going to decide whether it breaks a bank or not. I'm going to talk later on a little bit about, well, how do you get ready for this? I mean, is there any way you can position yourself so you don't just get completely sent to slaughter? And there are some things you can do to tell your story, but I thought it was maybe helpful for you all to see. These are some of the criteria that will be used. One of the more interesting pieces of CCPA, and it applies both to the sort of consumer rights piece that the Attorney General will enforce, as well as the data breach, is the opportunity to cure. So in theory, before you get sued, or the AG brings an enforcement action, you have to be put on notice. And you get 30 days to cure. So let's talk about, and there are some things that you probably can't cure, right? Some of the consumer rights things that we just shot up on the slide earlier. You can probably fix some of those within 30 days or come a long way toward it. But let's talk about a data breach. Can you even cure a data breach? Is there some way you can cure? Sean, why don't you talk a little bit about the vulnerability side of the data breach?
So I get these interesting vague portions of the CCPA. Again, from a technical perspective, once a data breach has occurred, the data's gone, right? There are very few instances where companies have been able to pull back the data and been able to prove that the person that stole it didn't do something else with it. There have been some, but they're few and far between. So typically, once a threat actor has access, you probably will never know what they did or didn't do with the information. So if you look at a cure from that perspective, I would say it's impossible to cure it once the data has left. But if they don't take that view, and they take the view of curing the issues that led up to the breach being able to occur. So, Bob, you mentioned a vulnerability. So if, for example, you had a website that had a vulnerability that allowed somebody to access information that they should not have been able to access, and the notification occurs, and now you're in that 30-day window of responding to the notification, and you're able to take the website, you're able to put controls in place that make it so that that type of attack couldn't occur again. You put controls in place to do a better job of assessing your externally facing websites. You put controls in place to better, you put a policy in place that says, here's what we're gonna do to prevent this from ever occurring again. Is that a cure? I don't know, Bob. I don't know. Again, I think we're gonna have to wait till either the CCPA itself is clarified or there's a litigation around a topic like that.
So I think the next question is, how do you respond if there's an incident? Let's call it that for now. I think historically, since we've been dealing with data breaches over the last probably 8 years, the default presumption is, well, if you think you've been breached, then you report. Safe thing to do. And actually, the Sedona conference has an incident response guide that is now on the cusp of final publication after it's been circulated for comment, that goes through in some detail on the various categories. And as I'm sure all of you know, the 50-state data breach process for reporting is not exactly efficient, and it's getting worse all the time because different states try to one-up. But just by way of things to think about, so you've got the regulators, some of which have to be told in some states before the consumers. Some are contemporaneous. Some states you don't have to tell them at all. Then you've got the consumers. Law enforcement, actually, depending on the nature of the incident, the FBI can be quite helpful. They're very open to talking with you. I know it's sort of an odd thing, but you might consider reaching out before you have any issue, just to get to know who they are. And then you've got all these sort of calculations about how do we satisfy this reporting obligation that's under statute, and then all of a sudden social media blows up, and it doesn't matter. All the best laid plans, and I mean, it's maybe poor horse that's been whipped too far, but as you may recall, the Target incident was, they were on the cusp of being out ahead of that when Krebs broke the story, and then it all just flew apart. So what I'd like to do with you is kind of walk you through some of the cascading consequences that you might have to deal with when you're faced with a possible data breach. I'm going to go halfway down here and just direct your attention to South Korea, which is 24 hours. And I was on a panel a few months ago with a South Korean regulator. He just laughed. He said, "We don't expect that." But how do you tell your CEO, you don't have to worry about meeting the South Korea standard? They're not serious about it. But anecdotally. So let's look at what happens under the various, we'll start with the assumption that GDPR might apply. Well, under Article 33, you have to notify the supervisory authority within 72 hours. Unless there is an exception, the personal data is unlikely to result in a risk to the rights and freedoms of natural persons. Just by way of context, the notification to individuals, which is Article 34, has the flip of that standard. You don't have to report to the individuals unless there is a risk. So I think the default has been, since GDPR was enacted, and a consultant actually used this term once, if it goes bump in the night, you report it. And in the first 6 months of GDPR, there were over 40,000 data breaches reported to the supervisory authorities in the EU, which means they're overwhelmed. They can't process this information. But over-reporting was safe. You don't get in trouble for reporting a breach that maybe wasn't a breach when you get more time to think about it. So let me though share with you what happens if you stay with that default. The first consequence you're going to face is if you happen to be governed by the New York Department of Financial Services, the commissioner requires notice to that office if you provide notice to any other supervisory authority. So if you're subject to New York DFS and you report to a supervisory authority under Article 33, you must report to New York DFS. Now, so and the standard here is very different. If you look, if you didn't have to report under GDPR and you were just looking at New York DFS regs, there's a materiality threshold. That materiality threshold does not apply if you report to any other supervisory authority. And I say this merely by way of example, because you're going to have potentially a complex series of equations you're going to have to run. And I think you'll really enjoy when Sean and Pete talk in a couple of minutes about real life scenarios, what you know and when you know it. And how does that relate to this? So you've got that possibility if you just play it safe and report under Article 33, you're going to have obligations in New York potentially. In Vermont, it's 14 days now, unless you've filed an incident response plan with the Vermont Attorney General. Who has filed an incident response plan with the Vermont Attorney General in this room? I'll bet somebody has, but so, it's 14 days. As you're going to see, it's a rare situation where you know enough to make a call within 14 days that nothing's really happened. So what else happens? Let's go back to being safe. If you have reported an incident just about to anybody or on the verge of it, insider trading blackouts. You saw, I think many of you may remember what happened in Experian. One was very egregious. The person actually knew. The other one was just serendipitous. The person traded, but they weren't on the inside. But this is for a publicly traded company. This is a big deal, and you have to get out ahead of this. So now you've got the IT people feverishly trying to figure out what happened. You got the outside forensic people trying to download stuff and get into it. And at what point in time do you tell your insiders that would be subject to an insider trading blackout? At what point in time do you tell them? Because once you tell them, it's pretty hard to keep it quiet after that. Securities and Exchange Commission regulation FD, you can't disclose some things but not others. And then when you start telling your shareholders, the board, the stakeholders, the board, shareholders, employees, once this goes, it's gone. And a little bit going means social media make it gone. So, before we get into some of the scenarios that we're going to talk about, I think it's fair to observe that, the term has been used, I think it's quite accurate, the fog of breach. You don't know. There's precious little information you know 0 hour. A day later, you know a little bit more, but not that much more. And then when you get your incident response team together, the communication people are going to say, let's get out ahead of this. Let's get the story, so we don't get scooped. Fine. That's what communication people are supposed to do. And the lawyers are saying, well, wait a second. We don't know what happened here. Do you want to really go out there with this story? And now think about this. California, class action. When you get out with your story, if you don't know for sure, you just bought yourself a class action. And lurking in the background is social media. So now we're gonna let these gentlemen to my left talk a little bit about how this works in real life. And I'm gonna ask both Pete and Sean, maybe just give us a flavor. So a company is dealing with an incident, and they may have one of the best IT departments in the world, but their legal and C-suite says, let's get somebody outside in here to help. How does that work when you guys knock on the door?
Yeah, so I'll start and then I'll punt it over to Pete in a second. So Crypsis, the company I work for, does a lot of work as it relates to insurance, right? So cyber insurance, when I first got into the digital forensic investigation or incident response work stream, it wasn't very common. Actually, there wasn't any cyber policies that were really being issued. Nowadays, I would say, at least for us, the majority of the clients we work with are coming through the insurance process. So as part of that insurance process, when they go to their insurance carrier and say, we think we've had a breach, the insurance carrier is going to start providing them with advice, providing them with resources, communicating to them what their policy is and what it means, and hopefully the company already knows it beforehand. I would say you probably aren't surprised that a lot of people at the company probably don't really understand what their cyber insurance policy really allows for. But prior to that, there is typically some work that the the internal IT is already doing to determine whether there's something that has to be reported to insurance in the first place. Because they're not just going to go to their insurance company and say, we've had an incident, without having some evidence, having conducted some sort of investigation to validate whether there has been an incident. So Pete, can you walk through, just at a very high level, what there's initial things that the internal IT is typically doing to verify that an incident has or may have occurred?
Yeah, so when we get called in to respond to an incident, as Sean noted, the internal IT team, if you're fortunate, they've gone through their process to do some level of initial investigation. They probably have a pretty good idea of maybe what might be at risk, what systems were accessed. So from an external consulting company coming in the door, we're going to want to have those discussions with the internal IT team to get a leg up on the investigation and start to understand what we're looking at as far as the scope of the incident might be. From my experience, the success kind of varies on how prepared the organization is to deal with the incident. So if they have an IT team, is the organization prepared to start that investigation process, or are they looking for a company like Crypsis to come in and help them through that? So if we're just thinking from like a timing perspective, a lot of times when the internal IT team or internal forensics team has done some initial investigation steps, it can really help speed up that timeline as far as when the investigation starts to when you start determining things like data access or data exfiltration. So it can certainly be a positive thing when the IT team is prepared and the company is prepared to handle that type of incident.
And I want to look at that last sub-bullet just very quickly on this slide, which is the dual forensic consultants. We see this a lot in PCI investigations where credit card information has been compromised. And the company or a company can bring a forensic team in through the panel itself, and that team is going to be working through the process, and at the end of the day, may issue some level of report that, if it ever goes to litigation, may become public. What we see a lot of times as helpful is if there is another forensic firm that is sort of shadowing the investigation and providing advice to the company itself as they're going through the process, where the communication with that firm is kept completely confidential. It's entirely under attorney-client privilege. I have not yet seen an instance where the attorney-client privilege has been successfully breached during litigation. So I've been on both sides of it. I've been on the side who's come in and said, I want access to the work that the second forensic firm was doing, and we've been denied. No, that's under attorney-client privilege. We are not going to allow you to, it's all privileged. I've been part of the firm that was doing the shadow, and at the end of the day, our work product was not able to go to the plaintiff in that case. So if you think you're in a situation where litigation is likely and that the scope of the litigation may become extreme, having another company brought in that's working solely for you can be very beneficial and should be something in your playbook to decide whether it's something you want to do or not.
Yeah, the privilege issue is a tricky one, because what's privileged is providing legal counsel. The actual communications would be privileged between an attorney and client. Also, in leading up to that and developing facts so you can provide legal advice, where we would often retain somebody like Cripsis. That would be work product. That is not absolutely protected, but for the most part it would be protected. And actually I've never seen that protection overturned thus far. So it is not an insignificant thing to think about. I want to go back just 1 second, Pete, and ask, because you talked about how internal IT can often speed your work up. Have you had experiences where internal IT maybe didn't quite get it right the first time and it made your job more difficult, as they, as I say here, didn't preserve the crime scene?
Yeah, absolutely. I've seen success, where the IT team's been great, but on the flip side, we've certainly had situations where the organization wasn't prepared to handle the incident from a forensic preservation standpoint. Some examples that just come to mind is, the IT team has good intentions, right, and helping with the investigation, helping preserve data. However, sometimes we might find that in the process of gathering the forensic evidence or collecting logs, for example, I've seen instances where things have been overwritten inadvertently, but with the lack of experience in collecting that type of data, we've certainly run into situations where, although they've tried to be helpful, and they have inadvertently overwritten data, maybe had remediated a system that shouldn't have been remediated, and we'll get into that when we talk about things like ransomware, where they're trying to get systems back up and running. However, in that process, they've started remediating systems, wiping them in order to get business operations up and running. So, certainly have seen that, have come across that from time to time.
And let me make just one more quick comment. The other thing we run into quite frequently is that the company security posture was not such pre-breach to even allow an investigation into what occurred to take place. So a perfect example is the company did not maintain logs. And as such, when we get in and come in to do the investigation, there are no logs for us to analyze to attempt to determine what occurred. I would say if that's the case, reasonable security argument could probably be discounted in that case.
So we have about 15 minutes left. And we have 3 scenarios that we'd like to walk you through, so you get a flavor of what it's like. So if, God forbid, the day comes when you're there and you're watching the clock tick, and you're thinking, what do we have to, how much time do we have? How quickly can we learn things, what we have to learn to deal with the reporting obligations? So what I've asked Sean and Pete to do is, you know, when you get into this, there's a cadence to it. And it depends a little bit on the circumstance, both what the attack was, what kind of IT capabilities you might have. But one thing that it's really helpful to have when this fog is going on, you can go to particularly the outside forensic people, because they've been around the block a lot. And what they can tell you after a few days, not a few hours typically, here's what we're seeing, not seeing, here's what we kind of expect to see. So you start to get focused on what it is you might have to deal with. I will note that there's a feeling that, well, if no data were exported, then we're in the clear. Not so. Half the states don't require exfiltration. California does not require exfiltration to report. And the other thing, the reality is you never get certainty. You get closer and closer and closer to knowing what happened, but you only have so much time and so much resources, and the clock's ticking. So, guys, take us through scenario number 1.
So yeah, let's talk about business email compromise really quickly. Whether it's on-premise email servers or off-premise, such as Google or O365, I would say business email compromise cases are one of the largest categories of cases that we're responding to on a day-to-day basis. And while the focus may be, of the investigation may be on something like a fraudulent invoice being submitted and ultimately paid. And we've seen, by the way, fraudulent invoices in the 6 to 7 figures, wire transfers being sent based on a fraudulent email being sent. As an aside, who's seen the deep fake stuff where somebody's able to take a picture and make it look like somebody's saying something?
Yeah.
Some people. They also have that with phone now. And there was a recent article about a deep fake of a CEO of a company whose voice was perfect, calling a number, CFO maybe, somebody within finance, and saying, hey, Mike, I need you to transmit this amount of money. It's the person's voice. It sounds exactly like them. So I just do that aside to let you know the threat actors, as we stomp down, or as one area starts getting to be a little bit controlled, they're just going to pivot to some other attack. But with these, the initial investigation may be about wire fraud. But we have to consider if access to the mailbox actually occurred. And in a lot of cases, it does. So the attacker was able to access the person's mailbox. What other information is in the inbox that may relate to CCPA or other reporting requirements? So I had an investigation a year and a half ago where a company in California had a couple of mailboxes compromised. And as part of the review, we were asked to do a review of all emails in the mailbox to determine what would the potential universe of sensitive information be. Now, luckily in this case, it ended up being about 30 individuals there's like 30 data elements associated with an individual. That is an insubstantial number. Because I've seen investigations, Pete, you probably have too, where somebody's account contained a spreadsheet that contained 30,000 rows of name, address, social security number, other sensitive information. But since the account was breached, we have to know what potentially the threat actor could have gotten. Can you talk a little bit from let's take O365, because I see a lot of movement to O365. Can you talk, by default, if you have an O365 account that's been set up and it's just the default logging, what can we get from logs?
Sure. So by default, in general, O365 retains logs for about 90 days. When you think about that, and you timeline it a little bit, considering when you were notified or when you've learned of the incident, how far into that 90 days are we? And have we overlapped that and have logs started to roll off? That's one thing to consider. However, as far as the logging goes, we can certainly tell if a threat actor has accessed the O365 environment from, pivoting from the IP address. Maybe it's a login from a foreign company or a foreign country, for example. We can also tell things like data access. So the logs might show certain queries that the threat actor has run while they're in the environment. So for example, we'll commonly see threat actors run keywords for payment or wire or deposit, for example. Other than that, we've seen threat actors set up forwarding rules. And again, coming back to the mailbox access or exfiltration, they could be exfiltrating email by just setting up a forwarding rule to an email address that's under their control. And then finally, and possibly kind of the biggie is an email sync. We might be able to tell from logs if a person's or employee's mailbox was synced. And so at that point, imagine what might be in that mailbox. Sean made the example of the spreadsheet and how far back that mail might go. So some things to consider.
So do you think, Pete, that for your run-of-the-mill, if there is such a thing, business email compromise, within say a couple of weeks, you've got a pretty good feel for what the damage is?
Yeah, and I think that largely depends, again, on how prepared the organization is to respond to this type of incident. Certainly, if you have logging enabled and we can get access to those logs on day one, we can start to get that information pretty quickly. Start triaging, what accounts may have been accessed, and then rounding out, tying up the loose ends on the investigation, day 7 to 14. Again, a ballpark, but assuming that the data is available, certainly a reasonable time frame.
I will say, I want to put one caveat in there. If a search of the mailboxes themselves for sensitive data elements has to occur, that is going to blow past the timeline we're talking about. Because we've seen cases where 30, 50, 100 mailboxes have been accessed. And we now need to download all that data. We need to put it into a search platform like Relativity. We need to run searches. We need to run queries. The first pass, you then have to send the results. Is this reasonable? Do we need to iterate our searches? So once you start talking about actually searching the mailboxes for what may have been compromised, I wouldn't take 14 days as any sort of reasonable expectation.
Yeah, and I would agree with that.
So let's compare that with a ransomware attack. You're right, it's probably, they've been around, typically the ransomware attacks, they've been in your system for a while. And most of the damage is done by the time you know about it. So what do you do then? When you're called in and say, oh, hey, we're down. We're down. What do we do now? And we've all seen it. I mean, the company can't move. They don't have comm. So walk us through that one.
And again, I'm going to turn it over to Pete in 1 second. I'll say this. ransomware attacks are one of the more trickier things that we're involved with, because there is this tension between investigating what occurred and what may have been compromised and getting the company back up and running. And from an insurance perspective, goal one, a lot of times, is get back up and operational while preserving information that needs to be preserved. And maybe the investigation piece doesn't take place until a month or longer after the crypsis has been brought in, because we're helping them get back to operational, and then we do the investigation into what occurred.
So looking at just at this, so the remediation piece, what you might do is go first to getting systems running and then go back and investigate.
Very much so, yes.
So that may be if your investigation put off, that ticking clock is ticking pretty loud, because the company's primary interest is being able to function. So though I can imagine that would be a fairly significant issue. We got one more to do, but I want to talk about ransomware. How often can you say with some certainty, this is your run-of-the-mill ransomware? They're not trying to get data. They're not looking to get data such that you'd likely have a breach report in certain jurisdictions. How quickly can you get a feel for that, Pete, Sean?
I'll start by saying this. We sometimes, or a lot of times, see the ransomware attack as an attempt to hide the tracks of what else they may have been doing in the network leading up to the ransomware attack. So if they've been in the network 1 or 2 months, there's a lot of stuff they could have done prior to initiating the ransom. So we do sometimes see it as a clearing of the tracks to try to prevent an investigation from occurring. But I'll let you discuss it in more depth.
Sure, yeah. So, from our experience in investigating ransomware, the threat actors in the network for a fair amount of time, a couple months, and one of the things about that is that they're hands-on keyboard in some cases, because they're actually getting interactive access to various systems. They're seeking out those systems that are critical to the business to encrypt, and in that process, they're starting to, again, access data. So we might be able to see what data was accessed by the threat actor when they were, moving from system to system. But oftentimes, we don't have the complete picture in the investigation as far as exactly what was accessed or exfiltrated. Often we have certain bits and pieces of evidence, but there might be some limitations from what we've seen. As far as...
I'll just make one more point there. A lot of companies don't even have the tools in place to definitively state whether exfiltration occurred or not. Right. There is no tool in place that can say, here's the data leaving the network, which is why so many of the regulations don't require any sort of definitive exfiltration of data. And I think we're running out of time. So we need to probably skip over the non-ransomware.
Yeah, so let's talk about takeaways, but I just want to mention one thing. When somebody's been in your system, there may not be evidence of exfiltration, so you're breathing a little bit easier, but you may not even be able to tell what they accessed. And that increasingly is the hard piece of this, because you need access to trigger the breach. If they never got into PII, never even got into it, forget exfiltration, you don't have to report it. Now, you may report it, but you don't have to. So what are the takeaways, guys?
These investigations can take a while. And yes, ma'am. I'm getting the sign to wrap up. We're about to get the little poll to pull us off the stage. I think this slide does a good job sort of identifying best practices that we've seen for helping reduce it, right? have a retainer. If you have a retainer, you don't need to go through the MSA statement of work process at the beginning. You can immediately start working on an engagement. If you know or have an understanding of what the scope is prior to bringing the forensics in, it can really focus us on just those critical systems, at least initially, until evidence leads us elsewhere. And from a reasonable security perspective, since it is so vague, you need to be conducting those risk assessments to determine what is reasonable, or what do we feel is reasonable, and what do our attorneys tell us is reasonable.
So we've talked about data exfiltration earlier, so I think we're done. Thank you for your attention.
Sorry for putting you up.